the Child Care and Protection Act. Section 13, power to bring child needing care or protection before court. Subsection 1, any constable or authorized person may bring before a children's court any child in need of care or protection. Subsection 2, for the purposes of this section, the expression authorized persons means. Alright, so these are the persons other than the constable who can bring the child before the children's court. A, any probation and aftercare officer or any children's officer. B, any person authorized by the minister under section 87, including any person appointed by the minister on the recommendation of a welfare organization. Alright. Section 14, powers of court. Subsection 1, a children's court before which any child is brought under this part, or before which is brought any child in respect of whom any of the offenses mentioned in the second schedule has been committed, may, if satisfied that the best interest of the child so requires, shall make an order in accordance with subsection 2. Subsection 2. Alright, so these are the orders. An order under subsection 1 may A, require the child's parent or guardian to enter into a recognized or to a recognizance to exercise proper care and guardianship. Alright. So I guess, is this some sort of course or workshop that you have to attend? To enter into a recognizance to exercise proper care and guardianship. Probably it's some short course on parenting that they would have to go through, have to sit. But anyway, B, another order, commit the child to the care of any fit person, whether a relative or not, who is willing to undertake the care of the child. So they can order that the child be removed from the care of the mother or father and be taken under the care of somebody else. C, either in addition to or without making any order under paragraph A and or B, place the child for a specified period not exceeding 3 years under the supervision of a probation and aftercare officer or some other person to be selected for the purpose by the minister. D, prohibit for a specified period not exceeding 2 years any person found guilty of such offense: 1, from entering or residing at any premises at which the child resides, including premises the person owns or has a right to occupy, or 2, from contacting or interfering with or attempting to contact or interfere with the child, except that where such person is the child's parent, the order may set out such condition for supervised contact between that parent and the child as the court may think fit, having regard to the best interests of the child. So they can prevent you from going even into your own house if the child is there, but I guess with somebody else. But that would make somebody who is an abuser even more angry. and can carry out further violence against not only the child but the adult in that house. So they have to be careful. Alright. E. If there are reasonable grounds to believe that a person is likely to interfere with a party who has custody of a child, to prohibit that person from contacting or interfering with or attempting to contact or interfere with the party who has custody of the child. So this sounds like some divorce and custody battle. Alright, so this would be a prohibition order or a order of protection against contacting the person who has custody of the child. F. Where any person found guilty of such offense is a person having the custody, charge, or care of the child, to require that the person or the child or any other child who resides with that person to receive counseling for a specified period from a fit person qualified by his knowledge of psychology or psychiatry, appointed by the court. Alright. 3. Subsection 3. The government agency responsible for children or any party to proceedings under this section may apply to the court for a variation or discharge of an order if circumstances have changed significantly since the order was made. So the government agency responsible for children or to discharge the order if circumstances have changed significantly to have a variation or discharge of that order. Alright. Notice of any application under subsection 3 shall be guilty to all other parties to the proceedings at least 7 days before the date for hearing the application. Notice of any application under subsection 3. That means for a discharge or modification of the order shall be given to all other parties to the proceedings. So all involved would have to get a copy of the notice at least 7 days before the date set for the hearing. So 7 days or more, all parties involved would have to get that notice that there's an application for the children's court or the judge to make a modification to the order or discharge the order of protection. 5. If a children's court before which any child is brought is not in a position to decide whether any or what order ought to be made under this section, it may make such interim order as it thinks fit for the child's detention or continued detention in a place of safety, or for his committal to the care of a fit person, whether a relative or not, who is willing to undertake the care of the child. Subsection 6. Any interim order made under subsection 5 shall not remain in force for more than 30 days, but at any time within such period, the court may, if it considers it expedient to do so, make a further interim order. So, however, that in no case shall any interim order remain in force for more than 60 days after the date of the first order made under subsection 5. So the interim order can be no more than 30 days. And it says, if it considers expedient to do so, make a further interim order. So, however, that in no case shall any interim order remain in force for more than 60 days. So it seems like 130 day plus 130 day, maximum of 60 days. 7. If the children's court by which an interim order is made is satisfied on any occasion that by reason of illness, accident, or other justifiable cause, the child is unable to appear personally before the court, any further interim order which the court has power to make on that occasion may be made in the absence of the child. Right? So, if the court by which the interim order is made is satisfied on any occasion that by reason of illness, so they can make the order if the child is not present due to illness or accident or other justifiable cause. Alright. 8. In making an order under this section for the committal of a child to the care of a fit person, or for the placement of a child in a place of safety, the court shall consider the child's best interest and give priority to placing the child with a relative if that is not consistent with the child's best interest. Committal or placement of a child as follows. Alright. A. So they may place a child to live with a relative, or they may place the child in a location where the child can maintain contact with relatives and friends. B. Place the child in the same family unit as the children's brothers and sisters. Or C. Place the child in a location that will allow the child to continue in the same school. Okay, alright. So next time we look at section 15, power to take offender into custody.